This voiceover presentation is to provide an introduction to the legal skill of drafting. So, we'll briefly first of all look at what legal drafting is. In its very widest sense, legal drafting covers a lot. So it can cover things such as writing letters of advice to the client. It could even incorporate things such as making attendance notes at meetings and indeed attendance notes over the phone. But in its narrower sense, legal drafting covers drafting of documents which have specific legal effects. So they're designed to do specific legal things, and that might be changing legal rights and obligations, for example by transferring ownership, but it might also be in terms of creating legal obligations and duties, such as in a contract. It might also yet again relate to contentious issues, so it might be putting forward somebody's claim in a way that is appropriate to take forward in a court of law. So there's lots of different legal purposes and effects that you might want a document to have, and legal drafting very broadly encompasses the skill of creating those documents. I alluded to it a moment ago, but one particular distinction that's important to recognise is the difference between contentious and non-contentious drafting. So we tend to think of legal drafting, and also what we will focus on in this module is what we call non-contentious. It relates to non-contentious material, so it will be things like agreements and transfers of ownership, etc. Contentious relates to court proceedings primarily, so there are some underlying skills that are exactly the same, and a lot of them are, but there are also differences in terms of conventions and obviously the purpose of what you are drafting. So this slide provides some examples of the sorts of documents that might be considered as typical documents that require legal drafting. And before I reveal them to you, though, perhaps have a think about what I said on the last slide and have a think about identifying any documents that you would typically associate with legal drafting. Just give you a few seconds to have a think about that and jot them down. Okay, so what we might have come up with are things like transfers. So a very common skill is and requirement is to draft things like transfers of land, transfers of ownership of other bits of property. Another thing you might have thought about is wills. So that's a very important skill and very important document to draft. Obviously contracts, which hopefully you would have mentioned given what I've already said, but the contracts can cover a wide variety of different circumstances, requirements and purposes. So some examples there. Some contentious documents, which you may be or may not be familiar with, but things that are called statements of claim. So your particulars of claim for setting out your case, if you like, when you take things to court. And also the drafting of witness statements, so supporting evidence that goes alongside your statements of claim in a contentious court case. So why is drafting so important? Well, first of all, it certainly is a vital part of any lawyer's job, and you will be asked to draft and amend the drafting of documents as soon as you enter into a training contract, for example, or perhaps even as a paralegal. So it's a very important skill you need to have some understanding of and some experience of as soon as you get started. Again, it might be helpful to perhaps stop and have a think about what you think poor drafting, what problems poor drafting can actually lead to. And I'll give you a few moments to jot down a few of those. Okay, so just some suggestions. First and foremost, the document doesn't do what it should do. So in a very poor draft, for example, of a will, it may be that actually it's not valid because you haven't created it with the appropriate formality, and it doesn't have the appropriate clauses to make it a valid will, and similarly problems with transferring ownership of land. So that can be obviously a very important issue. It can fail to record properly what's been agreed. So if you're creating a contract and your drafting is not clear, or it misses out some of the points of agreement, then it doesn't actually record what has been agreed between the parties. It may not deal sufficiently with all aspects of the legal relationship. So there might be an agreement, but it might raise other issues of obligations and legal rights which you haven't thought about and could miss those out. Finally, another example might be that it just is completely unintelligible to other people. So either to a court, or perhaps more importantly to those people who actually have to use the agreement on a day-to-day basis, if for example we're talking about a contract. So there's just some examples of why drafting can be a problem. But boiling it all down, if you draft legal documents that don't work, it tends to lead to disputes, and it tends to lead to litigation and costs of your client, and ultimately that may well come back to you and you can be sued. There's a good example in Modern Legal Drafting by Butt and Castle. There's several examples, but one in particular refers to a case about a letter of advice. So in a sense it's not drafting a document as such, it is advice about a legal document. But the combination of the document itself and the explanation of the letter of advice led a court to actually comment that the advice was so unclear on what the break clause said that it anaesthetised the legal secretary of the company who was reading it into oblivion. They basically were so perplexed by what on earth it was that the advice was trying to give that they just proceeded on the basis of what they thought was possibly correct and then got the wrong advice, and that cost them £95,000, which ultimately had to be paid by the solicitor. So it can be an expensive business to get drafting wrong. Okay, so what we're going to look at now is effectively what we are looking to teach you over the course of the Lawyer's Skills module. So first of all, this slide is just to give you a general overview of the sorts of things that we'd like you to be able to do. So first of all is understanding and recognising some basic principles of good drafting, which we will come to. One of those first key principles is being able to identify what the client wants to achieve and actually implementing their instructions. So being clear on what you're being asked, being clear on ultimately what the client wants to achieve. So why are they entering into a contract, and understanding the background, recognising what factual and legal issues are relevant to drafting. So again, what is it that wants to be achieved, but also how is that done with your legal knowledge. So to give an example, referring back to creating a valid will, you might be very clear on what the client wants to achieve, but you've actually got to ensure that the will does actually comply with all of the legal requirements that are necessary to make that happen. One important aspect, which we'll come on to in the next part of this lecture, is to think about the use of what are called precedents. So very briefly, precedents are really just templates which we can work from when drafting legal documents. They're very helpful, but they also carry their risks. So being able to identify, choose, and then adapt useful precedents is an important skill in legal drafting. As we go through the course, you'll be introduced to some precedents that will help you drafting the exercises we're looking at, and also that will be useful for your assessment. Some really important aspects of drafting are being able to use accurate, precise, straightforward, and hopefully modern language, using correct spelling, grammar, syntax, and punctuation to make sure that things are as unambiguous as possible, ensuring that the document reads well, it's easy to follow, it's logically consistent and internally consistent, so there isn't differences in descriptions of what words mean, or perhaps discrepancies in terms of clause numbering, or covering things twice, so it needs to be internally consistent. Again, hopefully that will then prevent ambiguity and misunderstanding. Finally, you also need to be able to sort of think about the structure of the document and identify when particular general clauses called boilerplate clauses might be necessary, when it's appropriate to use definitions, and when it's appropriate to use what are called recitals, and we'll have a look at those in a bit more detail in the next part of the lecture.